5 seconds to go. Start. The order of summoning issued by the Additional Chief Metropolitan Magistrate First Rouse Avenue Courts, New Delhi, in a criminal complaint of defamation filed by respondent number 1 herein against 6 individuals was challenged before the High Court unsuccessfully by persons arrayed as accused numbers 1 and 5, and hence both of them have come up with the above criminal appeals. We have heard Shri R. Venkata Ramani and Miss Pinky Anand, learned senior counsel appearing for the appellants, and Dr. Abhishek Manu Singhvi, learned senior counsel, as well as Shri Shahdan Farasat, learned counsel appearing for respondent number 1. On 19 July 2019, respondent number 1 herein filed a complaint under section 200 of the Code of Criminal Procedure 1973, hereinafter referred to as CRPC, against 6 individuals on the file of the Additional Chief Metropolitan Magistrate First Rouse Avenue Courts, New Delhi, alleging commission of the offences under sections 499 and 500, read with sections 34 and 35 of the Indian Penal Code, hereinafter referred to as IPC. The case of respondent number 1 in his complaint was that he has been the Deputy Chief Minister of Delhi since February 2015, that on 1st July 2019, Shri Manoj Tiwari, A1, who is the appellant in one of these appeals, held a press conference making false and defamatory statements as though the complainant was involved in corruption to the tune of rupees 2000 crores in the matter of award of contracts for building classrooms in Delhi government schools. That persons arrayed as accused numbers 2 to 4 in the said complaint shared the platform with the said Shri Manoj Tiwari during the press conference, and they also uttered the same defamation statements that Shri Vijender Gupta, arrayed as accused number 5 in the complaint, appellant in one of these appeals, tweeted defamatory contents against the complainant, and that the person named as respondent number 6 in the complaint also made defamatory statements in his tweets. According to respondent number 1 herein, the complainant, all the accused persons acted with common intent and in a well thought out and planned manner to defame him, thereby rendering themselves liable for prosecution. After recording the statements of respondent number 1 and 2 independent witnesses in the inquiry under section 202(1) of the CRPC, and after taking note of the documents produced by respondent number 1, the learned Additional Chief Metropolitan Magistrate passed an order on 28th November 2019 directing the issue of summons to all the 6 accused, after holding that there exists sufficient grounds to proceed against the accused numbers 1 to 4 under section 500 IPC, read with section 34 IPC, and against accused numbers 5 and 6 under section 500 IPC. The appellants herein, who were cited as accused numbers 1 and 5 respectively, challenged the order of summoning by way of petitions under section 482 of the CRPC before the High Court of Delhi. The High Court dismissed the petitions, forcing the appellants to come up with the above appeals. Though the petitions filed by the appellants under section 482 of the Code were dismissed by the High Court of Delhi by a common order, the cases of both of them are not exactly the same. Shri Manoj Kumar Tiwari A1, the appellant in one of these appeals, is accused along with accused numbers 2 to 4 of committing the offence punishable under section 500 read with section 34 IPC. But Shri Vijender Gupta A5 is accused of committing an offence punishable under section 500 IPC alone. In paragraph 14 of the summoning order dated 28 November 2019, learned Additional Chief Metropolitan Magistrate has recorded the following opinion. Further, the exhortation by the respondents as to sharing of the statements and holding a joint conference together also strengthens the inference of common intention of the respondent number 1, 2, 3, and 4. As far as the tweets made by respondent number 5 and 6 concerned, that have been made after few hours of the press conference held by the respondent number 1 to 4. Hence, the act of respondent number 5 and 6 cannot said to be done with common intention along with other respondents, rather they are individual acts of defamation. Keeping in mind the above distinction between the case of Sri Manoj Kumar Tiwari and the case of Sri Vijender Gupta, let us now proceed to consider the grounds on which the summoning order is challenged by these appellants. Stop.